All right, let's get right into it. Welcome to This Explainer. Today, we're diving deep into the absolute foundation of civil litigation. We are going to look specifically at why courts reject invalid plaints, basically why cases get completely thrown out before a trial even truly begins. If you've ever wondered how the legal system filters out lawsuits, you're definitely in the right place.
So let's clear something up right out of the gate. You might be wondering, hey, can I just take someone to court myself? Well, you absolutely have the right to represent yourself. In India, it's called being a party in person, governed by Section 32 of the Advocates Act and Order 3, Rule 1 of the Civil Procedure Code. You literally don't need a law degree to argue your case. But, and this is a massive but, there is a huge catch when it comes to the paperwork. And honestly, this is exactly where most self-represented folks completely derail their own lawsuits. Here's our quick roadmap for this explainer. First, fighting your own case. Second, the anatomy of a plaint. Third, what I like to call the 6 deadly sins. And finally, the all or nothing rule. Okay, let's kick things off with Section 1, fighting your own case and what the party in person experience actually looks like. You see, while the law absolutely allows you to fight your own battles, the court's procedural rules are frankly overwhelming. It's like navigating a giant maze. You might know the facts of your dispute perfectly, right? You know who wronged you, you know exactly what contract was broken or how much money they owe you. But the thing is, courts don't just run on facts. They run on incredibly strict procedural rules. And when you're emotionally attached to your case, it can totally cloud your judgment, making you miss those absolutely crucial procedural steps you need just to get the judge to listen to you in the first place.
Right. Moving to Section 2, the anatomy of a plaint. This is literally the foundation of your lawsuit. So what exactly is the bedrock of a civil case? It's the plaint. Think of the plaint like pouring the concrete foundation for a building. If that foundation is cracked, the entire house just comes crashing down. Governed by Order 7 of the Civil Procedure Code, the plaint is the very first document that kicks off a civil suit. It tells the judge who you are, who you're suing, what happened, and exactly what you want the court to do about it. Without a flawlessly drafted plaint, your lawsuit basically doesn't even exist in the eyes of the law.
Just to cut through some legal jargon really quickly, the plaintiff, that's the person suing, goes on the offensive by filing the plaint. In response, the defendant raises their shield by filing what's known as a written statement. It's exactly what it sounds like, a point-by-part rebuttal to your plaint. So plaintiff on the attack with the plaint, defendant on defense with the written statement. Make sense?
Now, under Order 7, Rule 1, your plaint absolutely has to contain some specific ingredients. This isn't just a polite suggestion, it's a rigid checklist. You can't just write a casual letter to the judge. You have to explicitly state the name of the court, detailed descriptions of the parties, the exact facts giving you the right to sue, which is called your cause of action, why this specific court has jurisdiction, the monetary value of the suit, and the exact relief you're asking for. If you miss even one of these, you're in deep trouble. Your foundation is already crumbling.
So what does the actual life cycle of this document look like? Well, once you draft it, you print it in duplicate, and you physically present it to the court. The court then does a strict examination to make sure you've paid the right court fees and that they actually have the power to hear the case. Then comes a critical fork in the road. Your plaint is either admitted, meaning great, the trial begins, or it is rejected completely, up front before the defendant even walks into the room.
Which brings us to Section 3. Let's look at the 6 deadly sins, or exactly why plaints are essentially dead on arrival. Under Order 7, Rule 11, the court is basically acting as a bouncer, guarding against these 6 procedural tripwires. Let's walk through them because any one of these will kill your lawsuit instantly. Rule 11A is the big one. If your document doesn't show a valid legal reason to sue, you're out. 11B and C are about the money. If you undervalue your claim to save on fees or use the wrong stamp paper, you're flagged. 11D means the suit is legally blocked, like maybe the statute of limitations expired. 11E is a total administrative blunder. You just forgot to bring 2 copies. And 11F means you failed to provide the necessary copies to summon the defendants. Now, courts aren't completely heartless. For things like valuation or stamp errors, those are Rules 11B and 11C, the judge might actually grant you a brief window to fix the paperwork. But if you miss that strict court-mandated deadline, that's it. The judge will essentially say, look, I gave you a chance, you didn't take it, we're done here. It becomes an automatic, non-negotiable rejection. Take a look at this. In the landmark case of K.C. Verma versus Union of India, the Supreme Court made it crystal clear. If you fail to articulate the why of your lawsuit, your plaint is completely untenable. That cause of action is the specific bundle of facts giving you the legal right to sue.
If your plaint reads like a vague, rambling list of complaints without pinning down an actual legal violation, the court literally has no choice but to throw it out under Rule 11A.
All right, let's head into our final section, the all or nothing rule, and some Supreme Court precedents on these rejections.
This is where the law gets incredibly unforgiving. As the Supreme Court ruled in cases like Sopansukdeo Sebo and Kumgila Gita, a judge cannot just surgically save the good parts of your document. Imagine you have 3 totally valid claims, but you mix them up with one invalid claim that violates the rules. The judge isn't going to pull out a red pen, cross out the bad paragraph, and say, okay, let's proceed with the rest. No way. If any part triggers a fundamental rejection under Order 7 Rule 11, the entire document is dead. It's completely an all or nothing scenario.
So, what's the big takeaway from all this source material? It's that while the right to represent yourself is a vital guarantee of the justice system, you don't get a free pass on procedural law. The strict necessity of procedural perfection is never waived just because you're a non-lawyer. The courts are designed to ensure fair trials, and that absolutely requires clear, compliant, and legally sound initiation documents from the jump.
So, I'll leave you with this final thought. Knowing your rights is one thing, but knowing the rules, that's what actually keeps you in the game. Before you decide to go to battle as a party in person, you really have to ask yourself, are you ready to not just argue your facts, but to master the complex, unforgiving procedural matrix that governs the courtroom? Thank you for joining me for this explainer, and keep learning.